Upon conviction of a traffic violation or a criminal offense, individuals are typically required by the court to make monetary payments as part of their punishment. The total amount of debt that is owed by an individual is known as court-ordered debt. Individuals are typically required to either make full payment or to set up installment plans immediately upon conviction. Debt that is paid on time is known as non-delinquent. If debt is not paid on time, it becomes delinquent, and collection programs are authorized to use a variety of tools, such as wage garnishments and additional fines, to motivate an individual to pay their debt. While counties are statutorily responsible for the collection of court-ordered debt, collection duties are often delegated to the courts. Payments that are collected to satisfy the debt are subsequently distributed to support various state and local programs, such as trial court operations and victim assistance. In our recent report on the state's current court-ordered debt collection process, we identified a number of weaknesses in the existing process. Because debt revenues are used to support a variety of state and local programs, the state has an interest in ensuring that the total amount of debt collected is maximized and that the cost or the amount spent to collect is minimized. In other words, the state has an interest in ensuring that collection activities are carried out in a cost-effective manner. However, the existing model for collections provides little incentive for programs to be cost-effective. For example, there is almost no direct relationship between a court's collection efforts and the amount of revenue it will ultimately receive. This provides it with little incentive to maximize the total amount of debt revenue it's collecting. Additionally, the state currently only offers reimbursements to programs for the cost of collecting delinquent debt. This offers little incentive for them to collect non-delinquent debt when it's less expensive to collect. Second, we find that it is difficult to comprehensively evaluate and compare the performance of collection programs due to a lack of consistent, accurate, and complete reporting on how programs collect debt. In light of all of these major weaknesses, we offer several recommendations to improve the current collection process. First, we recommend that the legislature shift statutory authority for collections to the trial courts and implement a new incentive model. We find that the courts are best positioned to interact with debtors, and that shifting statutory authority to them would also allow for increased state oversight of collections. The new incentive model would reward courts for increasing their collections by allowing them to keep a portion of the increased revenue for their discretionary use. Additionally, the new model eliminates the distinction between non-delinquent and delinquent debt and places limits on the amount a collection program can be reimbursed for its collection activity. This restructured process offers several benefits. First, it provides courts with greater flexibility in how and when they collect the debt. And two, it rewards them for becoming more cost-effective or increasing the total amount collected. We would recommend that the legislature authorize a 3-year pilot program to test the incentive model before implementing it statewide. Second, we offer several recommendations to enable a comprehensive evaluation of the court-ordered collections process. For example, we recommend consolidating reporting on collections to the judicial branch and also improving the metrics used to measure how well a program is performing. We find that these recommendations would improve the efficiency of the debt collection process and also maximize and increase the total amount of debt that's collected and subsequently distributed to the state and local governments.